In the criminal trial involving Mr. Zuma and Thales South Africa Pty Ltd, cited as accused number 1 and accused number 2 respectively. The first removal application couched in the form of a plea in terms of Section 106, subsection 1H of the Criminal Procedure Act 51 of 1977 was brought on the basis that Mr. Towner did not have a title to prosecute. The application served before my brother Kun J, who, following on a detailed judgment, decided, with the concurrence of counsel, to recuse himself as the presiding judge. I have decided, in the interest of justice, and also in accordance with Section 173 of the Constitution, to incorporate reasons for the order that will follow in my judgment. The question that requires determination is whether the retention of Mr. Towner as the prosecutor in the present matter would infringe Mr. Zuma's fair trial right entrenched in Section 35, subsection 3 of the Constitution. Mr. Zuma's application is anchored in what he terms in his founding affidavit 4 pillars, paraphrased as follows. Pillar 1, the private prosecution of Mr. Towner by Mr. Zuma. Pillar 2, allegations of disclosure of Mr. Zuma's confidential and private information, including Mr. Zuma's health condition, to Ms. Moon. Pillar 3, allegations of disclosure of information pertaining to Mr. Zuma's prosecution to Mr. Soul. And Pillar 4, an averment that Mr. Towner is not indispensable. Having had regard to submissions made by counsel, the relevant case law, and most importantly the 4 pillars relied upon by Mr. Zuma, I am not persuaded that Mr. Zuma succeeded in establishing that the retention of Mr. Towner as the prosecutor in this matter could prejudice his right to a fair trial enshrined in Section 35, subsection 3 of the Constitution. I therefore make the following order. The application for the removal of Mr. Towner as the public prosecutor in the criminal prosecution of Mr. Zuma and Thales South Africa Pty Ltd is dismissed. Reasons shall be incorporated in my judgment.
As the court pleases, my lord. My lord, of course, we not want to put pressure on the court, but if our instructions were to get an indication, maybe as far as the reasons are concerned, my lord, just in terms of when we would expect those, because obviously we would need those to trigger any further proceedings. So, and I mean, I'm not looking for a date, just a kind of indication, my lord.
Well, reasons will be incorporated in my judgment at the end of the trial.
Oh, I see. So there's no reasons
yes.
To be given at this stage. Ah, I see. As the court pleases, my lord.
My lord, I think it's incumbent on me now to take up the cudgels once more in the light of your lordship's ruling. Your lordship will recall that this matter was postponed for trial before this very court, before your lordship, to the 27th of April last year, 27th of April 2023, on which date, or thereabouts, my learned friends for accused number 1, Mr. Zuma, brought this application, which has now been ruled upon. So we're back to the status quo ante, which is the position which pertained on the 27th of April last year. That is that this matter must now be postponed for trial.
Yes.
So I would move that this court determine a trial date, and in terms of the availability of the court calendar, we have researched and consulted with our colleagues who control the roles in this division, and we are told that the roles are open from the 3rd term, and as your lordship also knows, we have always wanted to reserve at least 2 terms for this trial to run. So the 3rd and the 4th terms are open. in this division's court rolls, and those dates are the 22nd of July to the 20th of September, the third term, and the 7th of October to the 6th of December, the fourth term.
Yes.
My Lord, the court will notice that the representative for accused number 2, Tales, is not here at court. They have a holding counsel who holds a brief just to stand in today for Mr. Roo, who's otherwise detained. And I have had some discussions with Mr. Roo, and counsel has asked me to explain in his absence what the nature of that discussion was about availability. Mr. Roo informs me that he's not really available this year, and he proposes dates in the second term next year of 2025. I indicated to Mr. Roo that we understood his predicament, but we certainly do not agree that this matter, which many courts have found has been the subject of unreasonable delays for many, many years, and at least in this latest phase of the case since 2018, we're now in 2024, that's 6 years on, and we still haven't really started the trial, we've only pleaded. So that we don't find acceptable, and I've told Mr. Roo that. And I said, well, don't you have any dates of availability prior to that? He said he could make a plan in November of this year, November 2024, for 2 weeks, the last 2 weeks of November, I think that's from the 18th of November, at least to start the trial so that we could start leading evidence, sort out the consequences of the plea, etc. And I said I would inform your lordship of that. I informed counsel today of that, and he said that I could tell the court that. We, of course, as the state, don't agree with that. We're now sitting in March 2024 for a trial which has been the subject of abuse and delay for 6 years to start further down the line than 6 months from now. We just find it unacceptable. Naturally, the matter is in your lordship's hands, and bearing in mind counsel's availability.
Yes, it also depends on counsel's availability.
Absolutely, my lord. It is a pity, my lord, because you'll remember that we would have preferred that this matter be postponed provisionally to various trial dates, and that was not, that the court didn't make such orders. So we have always been keen to get this matter moving. So I don't know what the attitude of counsel, my learned friend for accused number 1 is, but certainly the state's attitude is that this matter must go to trial absolutely as soon as possible. And it's not as simple, so we would argue, that it's just simply the availability of counsel in the normal course. This is an unusual matter. And just as various courts make various rulings that their matters must take precedence, I would argue, and the state argues strongly, that this court should take the view, with great respect, that this is a matter of great importance. And in the pecking order of cases on the court rolls in this division and in other divisions of our country, this matter should be accorded the highest priority. And if other matters have to be moved because there has been a direction from this court that this matter must be given priority, then this court, I submit with great respect, should consider such an order. So our application, well, let me just say this one last thing. We don't have an application for leave to appeal from my learned friend for accused number 1. He says he's still considering his position. So in the absence of any such application, we can proceed to set the trial date. If there is any application which needs to be dealt with in the interim, I'm sure that we can work that out by the arrangement of timetables and the exchange of papers in the normal way, in which we have dealt with such matters in this very case before various courts, and it's worked well with great respect. So I would submit that your lordship would be free to make an order for the trial date. We can make arrangements. My learned friends can make arrangements. And in the interim, if there are any interim matters which have to be dealt with, we can do that by a mutual agreement, which we always manage to reach, and naturally in consultation with this court, with your lordship. Yes. And we can deal with those matters absolutely as expeditiously as possible.
Right, yes. Mr. Mpofu? Thank you, Mr. Downer. Yes, Mr. Mpofu?
Yes. Thank you, my lord. My lord, well, firstly, let me just place this on the record maybe more properly than I did just now, cryptically. The lordship would notice that our client is not in court. We're indebted to the court for having excused him. for today. But in anticipation of the outcome, we took some detailed instructions. I was with him yesterday in another matter. And so we stand here, my Lord. Obviously, we had to deal with each scenario that might pan out today. So we stand with firm instructions to proceed with an application for leave to appeal, given the ruling now. What we did not anticipate, of course, in those scenarios was this scenario where the reasons are not given now, which the court has dealt with. But I don't think that changes much of the substance of what it is that we would do next. It might just change by which section we proceed, or some preliminary stages before the actual application for leave to appeal. Now, my Lord, I'm mindful of the fact that as we sit, my learned friend is quite correct. That application obviously will be done within the time it is. I'm simply placing it on record. I'm not pretending that it's already before the court. Now, given that scenario, my Lord, the situation, my learned friend, what he calls the status quo ante, is actually not the real status quo. The status quo ante, as we all know, is that once that application is instituted in due course, then the real status quo ante will be the status quo ante which pertained here 10 minutes ago before the ruling. So that's the first submission. The second one, my Lord, is that, and just for the record, that status quo ante will be the fact that pending the outcome of such proceedings, we will be in exactly the same position that we have been for the past few months or since the recusal application was instituted. So that's the first submission. The second one, my Lord, is that I'm, to put it mildly, totally astounded by the submissions made by Mr. Downer. Maybe astounded is too much. I'm actually disappointed because he is going on about discussions that he had with Mr. Roo, rightfully so, as counsel in the matter. But he has not had any such discussions with us at all. Whatever he's saying here, my Lord, I can put on record. I'm hearing for the first time. Why he thinks that he owes Mr. Roo the professional courtesy to discuss what must happen if that, the scenarios, as we all do, but not the representatives who are accused number one, really is something I have never seen before. So be that as it may, given now what he has put to the court, obviously that then puts us in an awkward position, because we would, all these stories that he's talking about, the second term of 2024, the second term of 2025, Mr. Roo's attitude and all that, we have not had the privilege to engage in such discussions. So obviously we would have to, and he correctly says, and the court also says, that one of the factors to be considered is availability of counsel. Yes. Well, the last time I checked, we were counsel, so our availability should also be factored in, kindly so. And so that's one of the first issues. Obviously, we'd have to confer with clients. Secondly, I would have to check with my learned, with the rest of my team. Mr. Masuku SC is a very busy counsel. And then we could engage with Mr. Downer if he is willing to engage with us in the same way that he has engaged with Mr. Roo. He says, of course, I don't know what the attitude of counsel for accused number one is. He's right. He can't know it without talking to us. So, my Lord, we would then maybe, so that this doesn't really have to take place in open court, we would suggest some kind of interregnum. Maybe the parties can come back to your Lordship with some kind of discussed position, and we map up the way forward without even necessarily having to appear. kind of case management type of discussions, my lord. That's the only. Otherwise, we'll just be debating this in open court.
Are you then suggesting that the matter should stand down, Mr. Mpofu?
I'm suggesting that, my lord, indefinitely until the parties maybe come back to your lordship with some kind of proposal. That's just a suggestion I'm making on my feet, and I'm not sure if how it will work. As the court pleases.
Thank you, my lord. If the court would allow me to reply briefly to that, I'm very amenable to talking to my learned friend about available dates and how we propose to continue with this matter. Might I just say that to stand this matter down indefinitely, if he means to another date or sine die, the state opposes that with all the might that we can possibly summons. We're now in a criminal case. Criminal cases are not ordinarily postponed sine die. They have a date. On such dates, the accused have to appear unless they're excused, as has happened in this case. But nevertheless, we want a date. But, my lord, what I also want to say is that we'll have the discussions about the dates and our attitudes with our learned friends, but what I must put on record is that when I say the status quo ante, the state is serious about that, and we're not amenable in any fashion to go back onto the merry-go-round of timetables and the exchange of papers and appeals on this issue on which your lordship has ruled today in order to postpone the setting of a trial date. We do not agree to that, and we'll develop that argument properly at the relevant time if we get an application, but now we need a trial date, and whatever happens in the interim relating to appeals, etc., we can sort out with my learned friend, and we can sort out if we can agree on trial dates to be set now, today, because we move in all seriousness, and this is our serious application. We want a date, and that date must be preferably a trial date. What's to happen in the interim must be matters which we will discuss with my learned friend. So I propose that we do adjourn now for a couple of minutes. I'll discuss these issues with my learned friends, both of them, or all of them, for both accused, and we'll come back with the result, hopefully, with the most agreement that we can possibly reach.
How about adjourning the matter to a specific date in the next session for a pre-trial conference? Because I'll be here in Pietermaritzburg in the next session.
Yes, my lord. We can do that with the matter on the roll. That is not the state's first preference, because then, if we do that, then by that stage, my learned friend's diaries will have filled up again into the third and fourth terms of 2025, and we lose the trial.
But you don't know about that.
We don't want that, my lord. The public doesn't want it. We don't want it. The courts don't want it. Your lordship doesn't want it. It's unacceptable from every point of view, and we really have to make a stand on that now. And we've been very accommodating to my learned friends up to now. But the courts have ruled. The courts have ruled firmly, and we now need to move on in accordance with what all the courts have ruled up to the Constitutional Court in this matter. There are a couple of orders outstanding, but those are of no moment. Right. So I propose that we adjourn for, say, 10 minutes, 15 minutes now, and return with the result of our discussions. And your lordship can then make the appropriate rulings.
Yes, sorry, Mr. Mpofu?
My lord, I'm trying to contain myself, my lord. Of course, we don't agree with the proposal of Mr. Downer to want to force us to talk to him in 10 minutes when he has told us about extensive discussions that he has been having. He has not explained to his lordship why he didn't do the most ordinary thing of talking to us in the past 5 months since we've been waiting for this judgment about what might happen if this happens, if that happens. He obviously doesn't think he owes us or the court an explanation. But my lord, I don't want to belabor this. Mr. Downer tells us that he doesn't want it. The court doesn't want it. The public doesn't want it. Well, there's the small matter of the accused person here. It's the rights of the accused in terms of our Constitution, Section 35, that are paramount, not Mr. Downer's rights or whims. But be that as it may, my lord, our proposal is more akin to what your lordship was suggesting, because it's a via media We do accept, of course, Section 168 of the Criminal Procedure Act says that a matter should preferably be postponed to a date. We know that there are exceptions to that, and this probably is one of them. But Your Lordship, I think, gives us a kind of a halfway house, where there would be a date, but that would be a date for the pre-trial. Obviously, the implications of that are obvious. In that period, the parties will be able to engage, and whenever the pre-trial is held, then we'll present some position to Your Lordship. And if there are applications to be done, they would have been done. I think that's a more sensible proposal, my Lord, that it's postponed for that purpose, and then the way forward can then be mapped out. We can't be forced now. The client is not here. What are we going to say to him in 10 minutes? Even if we can get half an hour or an hour, we would have to consult with our client, just as Mr. Roo must have consulted with his client. As court pleases me.
Right, let's look for a date in the next.
We'll also do
Yes.
as long as it's not the 29th of May, man.
What's happening on the 29th? Oh, I see. Yes, the next session starts on the 15th of April, and it ends on 19 May, 15 April to 19 May.
The state is available at all times, my lord.
Now, you want to push it to the last day of the session? I can hear you saying 19.
Is that the last day?
Yeah, that's the last day of the session.
Okay, so it should be slightly before
Yes,
that.
yes.
Okay, thank you. If the court bears with me.
And so remind you, 19 will be a Sunday. Yeah, we can put it down on any day during the last week of the session,
Yes, madam.
starting on the 13th,
Which starts on the
13 to 17.
yes. My lord, yes, we could do the Friday, the 17th, madam.
Friday, 17.
17th.
Is the date suitable? All right. Yes, sorry.
For the sake of completeness, I appear for the second accused, tenant initials JW.
Yes.
I confirm everything that my learned friend, Mr. Dana, has said in relation to his discussion with Mr. Roo.
Mr. Roo. Yes, sir.
I'm merely standing or acting as standing counsel in the temporary absence of Mr. Roo, who is busy in another trial.
All right.
I will make submissions if necessary at the relevant time as to the availability of Mr. Roo.
All right. Right, this matter is adjourned to 17 May 2024 for a pre-trial conference.
As it please the court, my lord.
Yeah.
As court pleases, my lord.
Thank you. Right. We are adjourned.